Now I'd like to introduce Mr. Marshall Steinbaum. Marshall Steinbaum is Assistant Professor of Economics at the University of Utah. His research lies at the intersection of labor economics and competition law and policy, focusing on employer power in labor markets, particularly in the context of the gig economy. His research has been published in the Journal of Human Resources, Labor Economics, the University of Chicago Law Review, Antitrust Bulletin, and Law and Contemporary Problems, among others. He earned his PhD in economics from the University of Chicago.
Yes, I apologize, my camera isn't working, so you just have to have my voice and my slides. Thank you to the Turkish Competition Authority for inviting me to this conference, and I would echo what Ebru just said about Professor Heimler's presentation, that I found that quite illuminating, and the transaction cost approach, I think, extremely promising as to labor markets. I think I am in total agreement that sort of most of the existing landscape about how to evaluate competition in labor markets is not really represented in the larger debate about standards and protecting competition and consumer welfare. And I think that that sounds like a very promising way forward. I want to focus in this talk on the gig economy in particular and its antitrust implications. So here I'm really speaking of the context in which workers, people who labor for a living, are outside the regulated bounds of employment, as I'm reflecting especially on the legal context in the United States, but I think that is mirrored around the world, that there's more and more workers who work for a living who are not in the legal classification of employee, and that, to my mind, naturally brings forward a competition law evaluation of the labor markets in which they work. My general contention is that the gig economy relies on vertical restraints as we understand them in the context of competition law, and in particular, the reason why the gig economy, a major reason why the gig economy has become more prevalent, is more attractive as a business model way to operate labor, to hire labor and to direct it, is exactly because of the antitrust erosion of vertical restraints jurisprudence. So I won't go into a huge digression to the historical evaluation of vertical restraints within antitrust law, but suffice it to say that it used to be much more onerous, and starting in the 1970s in the United States, and I think emanating outward from there, competition enforcers and courts took the view that vertical restraints are in general pro-competitive and consequently should not be subject to liability except under somewhat extreme circumstances. And this invites, in my view, the direction of labor outside the bounds of employment. So in effect, the labor relationship is a relationship of subordination in which a boss tells a worker what to do. The regulated context of employment creates emoluments for the worker, that is, they are owed something by the boss in exchange for that economically subordinate relationship. Outside the bounds of employment, you can get an economically subordinate relationship that economically is exactly like labor, as we see in the gig economy, but in which workers are not owed the rights that are attendant to legal employees. And so that is what I think lies at the heart of the gig economy. I've listed a couple of examples of the types of antitrust concerns or competition concerns that arise in the gig economy context. So I'm thinking here of a platform that has putatively independent service providers offering their services on that platform, and then customers going to the platform to hire those services. The platform's legal position is in effect that these are third-party transactions, that the platform is neutral, and the platform is not a party as to the third-party transaction that's going on between the service provider and the customer. So many of the things that actually do happen, I propose, are the result of the dominance of the platform and the fact that they're not a neutral third party to that relationship. So just the very fact that individual service providers are matched to individual customers at the platform's discretion seems like market division within the context of the platform. That is, the service providers aren't really in competition with one another to service individual customers. There's also in not all platforms, but many of them, a strong price fixing dimension. So it's the platform who determines the price at which this punitively independent transaction takes place. I'll get to sort of the dimensions of the price decision on at the platform level in a second. There's a strong exclusion dimension. So this is, first of all, the idea that service providers can be deactivated by the platform. This is the main sort of disciplinary mechanism that the platforms have at their discretion, is basically to deny access to the platform to certain service providers on the basis of criteria that can be opaque. I would say beyond that sort of nuclear option vis-a-vis one service provider, there's the, this is sort of what the nonlinear bonus-based pay is getting at. There's also the use of bonuses and incentives to service particular geography. I mean, here I'm invoking the sort of ride-sharing context in particular, but service particular geographies, work at particular times in exchange for a bonus. The pay structure is such that essentially, you know, it's not economical to work a shift on a platform unless you earn the bonus, and essentially the bonus will make it very difficult to multi-home, even if it's technically possible. If you don't get deactivated just for having another app loaded on your phone, you can be deactivated for, or you not earn the bonus, and then at the other extreme, get deactivated for for operating in ways that would go along with multi-homing. So you have to work in certain areas unless you unless you don't get the bonus. You have to work at certain times. You have to accept a certain number of the tasks that are put before you by the platform, else you face some sort of discipline. Price and wage discrimination, I think, are both pretty rampant in the gig economy context. I think this gets, as I was saying, a little bit to the price fixing. One of the reasons, or one of the ways that a gig economy platform would defend itself from the claim that it is operating in an anti-competitive way is by saying, well, prices are lower on this platform than they would be through some other means of getting the same work done, including those means that depend on traditional employment relationship. That isn't always the case, but I would also say that the experiments that we saw that gained a great deal of attention in the early days of the gig economy labor platforms with surge pricing, the idea being that it would bring in more service providers to the platform at key times, and this would enhance consumer welfare. I think that has somewhat gone away, is my impression. That is, it was essentially a mass experimentation to determine individual level demand price elasticities of demand to enable a regime more of price discrimination than of surge pricing that is individually tailored. And I think it was largely successful in that. So as Professor Heimler was saying, there's an economic question about the competitive set, or the welfare implications of price discrimination and its implications for competition. I think it's not really in doubt that price discrimination or wage discrimination is evidence of market power. Then we could get to the question of whether that is in itself a harm to welfare versus part of a larger sort of business model that overall is anti-competitive, even if the discriminatory part of it is not the thing that we worry about reducing welfare. And then finally, the last thing on my list here is predatory pricing. And this more pertains to the platforms as a whole, using low prices and high wages in a sense to gain market share. This is what Lena has talked about in many contexts as a signature of the tech platforms more broadly, that they can swiftly get to essentially a monopolistic market share through below cost pricing, and then sort of ratchet that back once their dominance is achieved. I think in the gig economy context, we have seen some price increase. I mean, I'm most familiar with the United States, so I don't want to speak beyond what my knowledge is, but we've seen some evidence of higher prices on the consumer side, but we have definitely seen evidence of lower wages and lower pay, higher take rates, as it's called, on the worker side of these platforms. And I think that can very much sustain a sort of price discrimination, or sorry, a predatory pricing and a recruitment type interpretation of what the platforms have done. So I just threw in this story I saw recently on inequality.org about ride sharing in effect in a couple of developing economies. This is in the context of the Prop 22 passage in California that happened last month, which was in effect ratifying the non-employment status of gig workers across a number of different platforms in California. This is a live issue. I mean, it's still, I would say, a live issue in California, very much a live issue in other states, as well as at the federal level in the United States. I thought this was a very good article because it in some ways, the sort of coverage of the gig economy as a labor policy matter in the United States has not really attended to the competition concerns that I was just raising. And I like this article exactly because it does. So if you look at the narrative about this essentially a rickshaw driver in Cambodia, he's saying, well, I liked the apps when they first arrived because it was a way to easily meet customers, but little by little, I've lost all of my autonomy as an independent service provider. I can't charge my own fare. I used to bargain the fares. Now it's the app that decides how much I get paid. I get punished. That now all of the customers are on the app. So if I'm not on the app, I have no customers, and the app determines effectively everything about my business. So I thought that was, it's sort of like pretty much putting the competition concerns of the platforms front and center in a way that I think is useful for competition enforcers. So I'm going a little bit long here, so I should not go too far or not spend too much time on this. My overall point is that the reasons why the antitrust jurisprudence took a more permissive approach to vertical restraints don't apply in the case of the gig economy. That is my main contention. So we've got these elimination of double marginalization as essentially a principal agent problem between a dominant upstream manufacturer is usually the conceptualization, and then a downstream retailer of some kind, where the manufacturer is basically getting the agent to act in the interest of the principal. There's a sort of effort in, so that's I would say the main kind of thrust of the literature when you ask for vertical restraints permissibility. There's some of the literature that's expressly about inducing effort on the part of the subordinated retailer, usually that is, for example, through a exclusive dealing contract that they can't really if they can't do any other business, then they have to do, again, what the principal wants. And then there's the idea that essentially the sort of, I guess you say the positive flip side of inducing effort is that making the agents act more in line with the principal makes the overall company, the affiliate manufacturer retailer company more appealing to consumers, which enhances inter-brand competition. So none of these apply to the platforms. The one big reason is the platforms are the dominant entity between the workers and the consumers. So the elimination of double marginalization just isn't an issue there. In this sense, they're a third party, as they themselves say. So there's no real supply chain in the way that we normally understand it going on. Instead, the platforms have, as we know from the literature, they face a low platform-specific labor supply elasticity, such that they have wage-setting power over the service providers, as the Cambodian rickshaw driver illustrates. They wage discriminate. As I was saying at the beginning, they can impose penalties for multi-homing, even though they'll say that they don't do that. In fact, they do. And then we have evidence that they're taking a very high percentage of the revenues for themselves when all of the costs are located at the level of the worker. So, you know, the take rates that we've seen of something like 25 or more percent, and I should say there's also extreme variability based on the evidence that we have across this. You know, that is in effect, you know, a payment to a middleman. I mean, I wouldn't say that the middleman's providing no services, but it is not, you know, in a labor relationship, you know, the dominant employer would own the capital, and so, you know, they would be in some ways entitled to or require you know, a high share because they have a lot of costs. In the context of the gig economy, the whole premise of it is that the costs are borne by the service provider. All right, so finally, I'll just speak briefly about one case that sort of had this as a subject. It was a private case in the United States, which was a private consumer class action against, I mean, the title of the case is against the CEO of Uber. Eventually, the company Uber was joined to the case. Basically, it alleged a hub and spoke conspiracy. So Uber, Kalanick, the CEO, and the drivers are in a horizontal conspiracy per the theory of the case. And it focused mostly on the surge pricing because it was alleging, it was fundamentally the case was about a harm to consumers. And so they were saying, well, you know, the harm from this horizontal conspiracy manifests in the form of these surge prices, which are higher than essentially regulated taxi fares. That's the you know, anti-competitive harm basically of this conspiracy. The hub and spoke, you know, so obviously the legal landscape for a horizontal conspiracy is more favorable in general. In particular, this case was brought in New York, where there was a favorable precedent in the Apple eBooks case that found a hub and spoke conspiracy between Apple and the book publishers, and it sought to sort of use that as the precedent to say that the ride sharing was that. You know, as this presentation has been suggesting, my view of economically what's going on here is not really of a horizontal conspiracy, notwithstanding that the legal landscape would be more favorable to the plaintiffs on alleging that harm. Anyway, you know, under these facts, this case initially had a positive reception at the district court level, but it was sent to arbitration basically when the company was successful in imposing a mandatory arbitration clause, and ultimately the arbitrator the arbitrator found for the defendant on this specific injunctive relief about basically whether its control over prices, whether the platform's control over prices was a violation of the Sherman Act. There may have been damages in addition to that, but that was the main policy question in my opinion. So, you know, this is a fairly thin record of cases of this type, but I think as the gig economy becomes more prevalent, I mean, especially in the United States following Prop 22, you know, there's going to be efforts, I'm sure, to instantiate essentially the policy embodied in that law in other states. I think this extent to which the labor relationship becomes a subject of competition law and regulation in that sphere is only going to be more heightened over time as this business model gains market share.